issue on divorce has been a constant fixture in almost every Filipino's consciousness. It has remained a constant battle cry for many Filipinos, especially that the Philippines is now officially the only nation in the world apart from the Vatican City that has no divorce law after Malta legalized such. But this is not to say that the call for legalizing divorce in the country is unanimous. There are of course those who are against its legalization, and they certainly cannot be blamed. We live in a society where the influence of the church is very strong, so strong that it can be sometimes perceived as a vital factor that silently and in a very subtle way shape our society and our way of life. There is nothing wrong with this per se. The problem happens only when we allow religion and the church to dictate our respective realities. The Constitution is very clear on the separation of the church and state. This is one of the elementary principles in constitutional law. This is also the reason why the state is not allowed to aid the cause of one religion, or all religion for that matter, by setting up churches or passing laws in favor of any. This is implied in Section 5 in the Bill of Rights of the 1987 Constitution when it states that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. However, this is not tantamount to saying that the state's no divorce policy is greatly influenced by religion, particularly by the Catholic Church. For while the Church is very vocal in its no to divorce position, there is no direct and sufficient evidence to prove that the absence of a divorce law in the country is due to the state's submission to the will of the Church. To point to the Catholic Church as the reason or the driving force for the abolition of divorce that we once had until the enactment of the Family Code would be unfair to the Church, the same way that it would be unfair to view the state as lacking the political will to assert its independence from the Catholic Church. Now, why is this relevant? The state and the church are two distinct entities, and as such should be treated distinctively. We believe that it is important to revisit the independence they separately enjoy, because it will somehow lead us to the rationale, where both the state and the church exist in the first place. These two entities are so powerful, and their separation is inviolable as provided in the Constitution. They have their respective obligations, and this fact is beyond contestation. The Church's main obligation is to nurture the spirituality of its members through spreading the words of God, teachings that primarily became the backbone and the most powerful source or influence of our moral conviction, which inevitably set the canons of morality. Depending on our religion affiliation, our concept of what is moral and what is not may vary in consonance with our respective religious beliefs. The Constitution itself recognizes this fact. That's why we have the so-called freedom of religion, as provided under Article 3 of the 1987 Philippine Constitution, commonly referred to as the Bill of Rights. This right to choose which religion we want ourselves to be affiliated with in essence give us the liberty to believe what we want to believe, and as such is beyond contention and cannot be regulated by the state. This is equivalent to saying that nobody, not a person, not an entity, ever has the right to question what we believe, nor have the authority to decide what we must believe in. Nobody has the monopoly of our own thoughts but us. This is where the state comes in. The state in essence exists to reconcile our differences and promote the common good. Having said this, it must be clearly understood that the state does not aim to restrain our liberty nor limit our exercise of our inherent rights. It only recognizes the rights of others and respects their right to exercise the same. This is so because the state is implied or required to observe objectively so as not to favor nor prejudice a select group. To put things in perspective in discussing the issues surrounding the legalization of divorce, we must be sincerely objective and eliminate biases and prejudices in our approach. The reason for this is to prevent these biases to subconsciously operate and lead us to the danger of putting morality and legality on equal footing. To commit this error is tragic, for it could lead to a twisted conclusion that what is moral is right. This is not correct. Morality is never synonymous to right, neither that moral is synonymous to legal. Article 1 of the Family Code of the Philippines expressly states that marriage is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation. This is what the law says, and there is nothing we can do about it unless it is amended or repealed. Now take note of the concept of amendment and repeal. The idea of these two legal processes convey the thought that laws are not absolute, nor that they are forever. Laws are created pursuant to the declaration of principles and state policies, repealed when no longer relevant or applicable, and amended when needed, depending on the prevailing circumstances at the time of the amendment. Even the Catholic Church observes the impact of the changing times. This is evident when the Second Vatican Council stopped the practice prevalent during the First Vatican Council of priests facing the Eucharist while celebrating the Mass. This is the reason why today, priests celebrate Masses facing the people or churchgoers to facilitate the participation of the people. This is just one among the many changes in the Catholic Church as time goes by. But why are we pointing this out? We believe and collectively contend that while laws are presumed to be just laws, it must be viewed with respect to time. We say this because we used to have a divorce law in the country. It was once in effect, underwent an amendment, then subsequently repealed. But isn't this the exact same thing that happened with death penalty? We used to have a law that allows the taking of a life to serve the ends of justice. We used to end life to serve justice, life that our laws expressly protect. At the time when the death penalty was in effect, the people through the state viewed such as just until it was abolished. But the call to bring back death penalty because of the proliferation and increasing number of people committing heinous crimes never ceased to exist. Now what does this tell us? It only means that laws are just until they are no longer viewed as just, and this has a strong and direct link to the prevailing circumstance in existence at a given time. Like the death penalty, the divorce law went through the same process. History on divorce law. Spanish regime. Before the American regime, divorce law in the Philippines was governed by Las Siete Partidas as accepted laws by the Spanish government. LSB provided the provisions governing divorce, namely Titles 2, 9, and 10 of Partida 4. Under the provisions, relative divorce can be granted under following grounds. First, the desire of one of the spouses to enter a religious order, provided that the other granted permission to do so. Second, adultery committed by either. And third, the fact that either had become heretic. The divorce allowed by these laws was relative divorce or mere legal separation. The marriage was in no way annulled, nor was the marital bond dissolved. American regime. On December 18, 1899, Major General Otis promulgated General Orders No. 68, having the purpose of establishing rules relating to marriage and to the nullity of the same. The General Orders expressly repealed some of the Spanish marriage law of 1870, although the said order said nothing about divorce. In the treaty by which the Philippines were ceded to the United States, the doctrine of religious freedom was proclaimed for the first time. The treaty provided that inhabitants of the territories over which Spain ceded its sovereignty shall be secured with free exercise of religion. President McKinley instructed the Second Philippine Commission that the separation of church and state shall be real, entire, and absolute. Due to the new philosophy of the separation of church and state, the idea of legalizing absolute divorce in the country was introduced. On March 11, 1917, Act No. 2710 otherwise known as the divorce law, was passed. Absolute divorce was allowed under these acts on the ground of criminal conviction for first, adultery on the part of the wife, or second, concubinage on the part of the husband. The phrase, provided it is not contrary to law, morals, good customs, public order, or public policy, is present almost always in every law book and even jurisprudence. We read this all the time. This phrase is so encompassing that anything that is against the law, morals, good customs, public order, or public policy will never get the sympathy or affirmation of the courts. We do not contend this, and in fact, submit that if we use this phrase to assail any attempt to legalize divorce, said attempt will never prosper, as it is first and foremost contrary to law, for it violates the provisions of Article 1 of the New Family Code, which expressly states that marriage is an inviolable social institution. This is not, however, the point that we are trying to make. What we want to point out in this paper is the need for us to change our laws and recognize the need to legislate a new law that will legalize divorce, or at the very least amend the existing law and provide grounds for exceptions to the inviolability of marriage as a social institution. Because while we value the sanctity of marriage, we also value human dignity, and forcing a party in an abusive and destructive marriage to stay within the marriage simply because the law says so certainly is not the best definition of a dignified existence. Anti-divorce advocates, at the end of the day, always point to the inviolability of marriage as a social institution to assert their opposition to the legalization of divorce. They use this as a shield and a universal argument why marriage must not be dissolved. However, we on the pro side cannot only think of one, but an ample lot of reasons why divorce should be allowed at this juncture, one of which is the preamble of the Constitution.
We, the sovereign Filipino people, imploring the aid of Almighty God, in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace, do ordain and promulgate this Constitution.
The preamble of 1987 Constitution of the Republic of the Philippines, it speaks about a lot of things which are essentially the wishes of the Filipino people. It talks about a just and humane society, a government that embody the ideals and aspirations of the Filipino people, promote common good, uphold independence and democracy, and a regime of truth, justice, freedom, love, equality, and peace. The Filipino people have been clamoring for a divorce law to free those suffering from the ill effects of a failed, abusive, and destructive marriage. Based on several surveys, a greater majority of the Filipino people wants a divorce law in the country. Whether or not this is true, the state through the government should at the very least take initiatives to ascertain the claim, because it is implied in the preamble of the 1987 Constitution that when the Filipino people have spoken, the state should listen. The state is mandated to establish a government that embodies the ideals and aspirations of the people.
Majority of the population in the Philippines are Catholic, and as such, marriage is recognized as a sacred sacrament, and even under the family code, marriage is defined as the foundation of the family wherein a special contract of permanent union between a man and a woman entered into in accordance with the law for the establishment of conjugal and family life. Sadly, not all marriages end till death do us part as vowed. Some end in separation, divorce, or annulment for various reasons, such as physical violence, economic disputes, moral abuse, infidelity, fraud, and abandonment. In fact, around 10,600 cases of annulment are filed with the Office of the Solicitor General in 2012. Of the 1,300 weddings celebrated every day, 1 out of 5 married couples end in annulment. With alarming numbers such as these, how long does the process of annulment take? How many of these cases are declared as annulled per day? And what happens to the couple after their marriage is annulled?
The inviolability of marriage, while very noble is the intention, is in fact and in reality oppressive. It essentially punishes a party in a failed marriage and consequently binds him or her to the unfavorable effects of such without permanent remedy. One would argue that legal separation and annulment of marriage are both valid and legal remedies available to the parties in failed marriages, but we say that they are not. Legal separation allows the parties in a marriage to divide the properties and live apart. It does not dissolve the marriage. Annulment, on the other hand, apart from the fact that it is costly, does not dissolve the marriage either, because in annulment, there is no marriage to speak of in the first place, since the objective of annulment is to prove that there was no valid marriage to begin with. Hence, no marriage ever took place. How can one dissolve a marriage that never took place? In essence, both legal separation and annulment are remedies for failed relationships and not marriage. The absence of a remedy for failed marriages run counter to the principle of just and humane society embodied in the preamble of the Constitution. It does not promote common good either, for it indirectly encourages immorality, which is the exact opposite of morality in which the inviolability of marriage was founded on. Parties in failed and destructive marriages may resort to adultery, concubinage, and bigamy, which are crimes involving moral turpitude. Crimes that a physically, psychologically, and emotionally battered party in a marriage would have never committed should a divorce law was in place.
No place to hide, nowhere to run to. Open me up, tear me apart. Just play me over and over and over and over and over and over again.
Marital abuse is not something that should be taken lightly. While men can be victims of marital abuses, record shows that victims of marital abuses are mostly women. These may range from physical, emotional, psychological, and even economic abuse. The state recognizes this and through its law-making body enacted RA 9262 or the Anti-Violence Against Women and Their Children Act of 2004. Section 2 of this article states, Declaration of Policy, it is hereby declared that the state values the dignity of women and children and guarantees full respect for human rights. The state also recognizes the need to protect the family and its members, particularly women and children, from violence and threats to their personal safety and security. The state values the dignity of women and children and guarantees full respect for human rights. But this is clear from the words of the Declaration of Policy under Section 2 of RA 9262. The absence of divorce, however, does not show full respect for human rights and dignity of women and children, for it only partially resolves the result of the problem and not the problem itself. It only punishes the abusive conduct of the husband, causing detriment to the wife and their children, but does not resolve the real problem, which is the marriage itself. It failed to recognize that some marriages work and some does not. Failed marriages more often than not result to marital abuses. This is no speculation at all. In Albay alone, PNP Albay Provincial Office shows that in 2013, there were 77 reported cases of abuse to women. It skyrocketed to 1,497 cases in the year 2014. Take note that these figures pertain to those reported cases only, and only in Albay. The unreported cases could be more, but regardless of the figures, the fact that it exists and said abuses are real, victims should not be given limited relief. With the passage of a divorce law, victims will be given a holistic remedy. Should they decide to stay within the abusive marriage and try to work things out, it's up to them. We are not in any way against it. What we are trying to point out here is that should the aggrieved party in a failed marriage decide to eventually get out of such, he or she has divorce as an ultimate remedy at their disposal. It is not for the state to decide what one wants and what one should want. Anti-divorce advocates would cite the presence of annulment proceeding as a perfect remedy for failed marriages without destroying the sanctity of marriage. We say that it's not. As we have pointed out in the early part of this paper, annulment does not even recognize that a valid marriage existed in the very first place. Besides, the annulment process is so expensive that it constitutes discrimination between the rich and the poor. According to Attorney Alni Foha, one of the authors of the divorce bill, the civil annulment alone costs at the minimum between 150,000 to 250,000 pesos. Where would an ordinary Filipino get this amount if he decides to liberate himself from the bondage of an abusive and destructive marriage? Remember, this is just for the civil annulment alone. We still have the church annulment, where parties seeking annulment of their marriages must apply and undergo a separate annulment proceeding before the ecclesiastical tribunal of the church. The cost of the annulment itself leaves an aggrieved party no choice but to stay and endure the abuses and deny him or her the opportunity to rediscover happiness and celebrate life. Anti-divorce supporters would of course say that there is legal separation if one only aims to get rid of the abuses. Yes, it's true, but let's not forget that by abuses, we mean not only on the physical level. The fact that an aggrieved party is in fact still married is tormenting in itself. It does not dissolve the main cause of the problem. If divorce is readily available, we wouldn't even have this discussion. Some would argue that divorce ruins the very essence of a family. We say that it does not. Abuses ruin the very essence of a family. In fact, some experts believe that divorce could even be beneficial not only to the couple, but to their children as well. According to Dr. Shoshana Bennett, a clinical psychologist, media consultant, and keynote speaker, contrary to popular belief, divorce isn't always negative for kids. It could very well be beneficial. When parents are happier as individuals, the chance is high that their kids would be too, for they will eventually pick up their parents' happy and positive outlook. But when what kids see and experience on a daily basis is the contrary, the kids, especially when in their formative years, might end up developing an unfavorable outlook in life, which is detrimental in their moral and psychological development. The presence of divorce protects the children from any kind of trauma that a problematic and chaotic home could give as a result of an abusive and destructive marriage. The essence of a family is not their physical togetherness. A family living in the same roof may in fact only have a house and not a home. We live in a society where change is the only constant thing. It is about time, if not long overdue, to make some amendments with our laws to effectively address the needs of the people. In case of divorce, we need to be proactive and view divorce with relative liberality and objectivity. We believe that divorce is more humane and just as compared to annulment.
Yung anak mo, lalaki na walang tatay. Ang sagot ko sa kanya lagi, mas kawawa naman siya kung lalaki siya sa ganung pagsasama. Na hindi kami magkasundo. Para kang nabunutan ng tinik. Hindi lang sa dibdib, kundi sa lalamunan.
Pero annulment case na kanyang inihain noong 2004, inabot ng 4 na taon at halos 250,000 pesos bago tuluyang naisapinal ng korte.
Yung emotional burden ng process. Kasi marami kang binabalik-balikan and part ng process balikan mo talaga yung mga nakaraan mula sa umpisa. Parang nagsa-storytelling ka
Sapat ang kailangan ay pagganap. Ibahagi ang iyong panahon sa pagtugis ng nilalayo.
Divorce will limit the court's investigation and will not drag the abused party in a marriage to present and expose embarrassing life situation which will just add insult to injury by reliving each and every painful moment. We have laws for void and voidable marriages, but what we need today in these changing times is a law for valid but failed marriages. While those against the legalization of divorce claim that it is an issue of morality, we say that it's not. We might even concede that it could be an issue of public policy, but said public policy is not dependent on morality, but more on the generally accepted customs and traditions prevailing at a given period of time. However, we are in the now time, and where we are now, along with the prevailing circumstances of a lot of married couples, calls for a divorce law. Divorce should be made available to everybody who might have a need for it. At present, while the country does not have a divorce law, a valid exercise thereof is recognized but limited only to our Muslim brothers. This fact is discriminatory to other Filipinos who are non-Muslims, who unlike their Muslim brothers are afforded the right to end their marriages without having to go through the toxic process available to most Filipinos. We cannot agree as well that the reason for this is that the greater majority of the Filipino is Catholic. This contention can be easily stricken down by the fact that Ireland, whose population is about 87.4% Catholic, approved divorce in 1995. Spain, on the other hand, the country that brought Catholicism in the Philippines, legalized divorce as early as 1981. The entire world has legalized divorce. What does the Philippines see that others don't? Or could it be that it is us who couldn't see what others can? Even the Bible provides for exception to the inviolability of marriage. The state should reconsider the wishes of the people brought about by the changing times. It must act accordingly and listen to the battle cry of its people. Based on the fourth quarter of 2014 SWS survey regarding divorce, where an interview was conducted face-to-face with 1,800 adult individuals in Metro Manila, 60% were in favor of divorce while 29 opposed, and 21 provided an undecided choice. The station also provided that, for the total survey, 58% of married individuals agreed to divorce. This somehow merits a serious consideration from the state. Marriage is not exclusive to churches. We have civil marriages, and that is equally valid. If the church will not allow divorce, at least the state should. For after all, it is not the church, but rather the state was empowered by the people to uphold their ideals and aspirations. The church does not have the obligation to listen to what the people want, but the state has, for it is the people that empower the state by virtue of the Constitution.
Hindi ka